present. Without objection, the chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I want to thank all members for participating in today's markup, the first that we have held in a fully virtual format. We have successfully held hybrid markups and hearings with remote participation, and I believe we are well prepared to take this next step. I would ask all members to please mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I appreciate all the work that has gone into making this markup possible, and I look forward to consideration of the important bipartisan bills we have in front of us today. Pursuant to notice, I now call up H.R. 683, the Puerto Rico Recovery Accuracy and Disclosures Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 683 to impose requirements on the payment of compensation.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 683, the Puerto Rico Recovery Accuracy and Disclosures Act, or PRRADA, is bipartisan legislation that would promote greater transparency and integrity with respect to the ongoing financial reorganization of Puerto Rico. In response to dire fiscal issues facing Puerto Rico at the time, Congress passed the Puerto Rico Oversight Management and Economic Stability Act, or PROMESA, in 2016. That legislation established the Financial Oversight Management Board with control over Puerto Rico's budget, laws, financial plans, and regulations, and the authority to retain professionals to assist the board in executing its responsibilities. Although largely patterned on Chapter 11 of the Bankruptcy Code, PROMESA did not incorporate all facets of Chapter 11 and other relevant provisions of the code, including, for example, the code's mandatory disclosure requirements regarding actual or potential conflicts of interest that professional persons seeking to be retained in a bankruptcy case must make to the court prior to their retention. This bill would close that loophole, and to quote our colleague from New York, Ms. Velasquez, who authored the bill, it would improve transparency and restore confidence and integrity in Puerto Rico's restructuring process. I thank Ms. Velasquez for her leadership in championing this bill and for her relentless dedication to ensuring that the people of Puerto Rico receive the fair, efficient, and transparent restructuring process they deserve. I urge all members to support this legislation. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I understand that Mr. Jordan is not here today and that I'm going to be filling in for him. I want to thank you, Mr. Chairman, for and the staff for all the work that they've done in putting this markup together. I want to express a general concern about the fact that this is a fully virtual markup. Commerce is down the hall. They are having a hybrid markup, and I think that it would behoove us to also enable members to use the committee room to vote in person and represent their constituents in person as well. As to this piece of legislation, Mr. Chairman, for years, Puerto Rico was facing a growing financial crisis brought on by increasing debt and related obligations. As a result, Congress enacted the Puerto Rico Oversight Management and Economic Stability Act of 2016 to establish a bankruptcy mechanism for Puerto Rico to deal with its debt. As in traditional bankruptcy law, the 2016 law permits certain professionals to receive court-approved compensation for their services. However, the Puerto Rico bankruptcy process lacks disclosure requirements typically found in bankruptcy proceedings, creating the potential for unaddressed conflicts of interest. To close that loophole, H.R. 683 establishes disclosure requirements on professionals, such as business consultants and attorneys, seeking compensation in Puerto Rico's bankruptcy. With disclosure requirements more consistent with traditional bankruptcy law, the court is more likely to catch and address potential conflicts of interest, And this improved transparency is better for creditors, taxpayers, and ultimately Puerto Rico. Mr. Chairman, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 683, offered by Mr.
Without
Nadler.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute strikes the text of H.R. 683 and inserts the text of Senate 16 of S 1675, the Senate version of the bill. The key difference between the House and Senate versions is fairly subtle. Both versions allow a court to deny compensation to any attorney, accountant, consultant, and other professional persons employed by the Oversight Board tasked with managing Puerto Rico's restructuring if the court finds that the professional was not a, quote, disinterested person, close quote, as defined by Section 101 of the Bankruptcy Code. But the Senate version, and thus this amendment, is essentially forward-looking in that the court can deny compensation to any professional who is not a disinterested person on or after the date of enactment of this bill. The unamended text of H.R. 683, by contrast, would allow the court to deny compensation to a professional who did not meet the standards for disinterestedness at any point, including before the bill's date of enactment. By adopting the more forward-looking language of the Senate version of the bill, we will prevent the inadvertent disqualification of professionals whose retention was permitted under the law as it existed at the time they were retained. I urge support of this amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? Ms. Jackson Lee, do you seek recognition?
Yes. Good morning. Thank you very much. I'd like to strike the last word.
Gentlelady is recognized.
Thank you. For many of us who have been engaged with Puerto Rico for a number of years since the horrific hurricane and the devastating financial concerns, recognizing the importance of Puerto Rico to the United States and the people of Puerto Rico, which of course is part of the United States. These are citizens of the United States. I rise to enthusiastically support the manager's amendment for the Puerto Rico Recovery Accuracy and Disclosures Act of 2019. We well know, of course, that Puerto Rico still faces sometimes insurmountable obstacles in terms of its recent recovery of the hurricane, but more importantly, its fiscal health as well. This legislation does work more proactively to address the concerns dealing with the bankruptcy code. And unlike PRRADA, which one of the issues that I know we addressed with respect to Puerto Rico was the the inability to account for the funds that were being utilized that were either being given to be to assist the people of Puerto Rico. One of the challenges they had was the energy grid, and I remember the letting of contracts in that instance. So I support the fact that this provides for in the bankruptcy code authorized professional persons such as attorneys, financial advisors, appraisers, and others to be retained in connection with the administration of the bankruptcy code, that they meet the following conditions. First, such a person must not hold or represent an interest adverse to the bankruptcy estate. And second, the professional must be a disinterested person. H.R. 683, the Puerto Rico Recovery Accuracy Disclosure Act of 2019, or PRRADA, conditions compensation of professional persons retained under PRRADA upon the applicant providing certain disclosures similar to those required under bankruptcy code. In addition, it would require the United States trustee to review such disclosures and submit comments in response to the court, as well as authorize the United States trustee to object to compensation requested by professionals. Further, the measure would apply retroactively to professionals who had previously been awarded compensation. Would also authorize the court to deny allowance of compensation for services and reimbursement of expenses accruing after the bill's enactment date if the professional person did not comply with the disclosure requirement and was not a disinterested person or represented or held an interest adverse to the bankruptcy estate. I think the main point that I see HR 683 providing is an extra level of oversight that the people of Puerto Rico can be helped. We still have not finished our tasks in making them whole. There are still tragedies as it relates to both their financial health and, of course, the recovering from their most recent hurricane. So I believe this is a constructive addition to providing extra support for the people of Puerto Rico, that the funds utilized will be utilized for the enhancement and improvement of a better quality of life. And with that, I support the manager's amendment and yield back my time. Ask colleagues to support the legislation.
The gentlelady yields back. Does anyone else seek recognition? In that case,
Mr. Chair, it looks like Andy Biggs wants to seek recognition.
Mr. Biggs then is recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to speak on this bill as a co-sponsor of this bill, and I appreciate your amendment. And I would just tell you that public confidence in our legal system is the cornerstone of a healthy republic. And when conflicts of interest or cronyism are present, it destroys that faith. And that's why I joined a really bipartisan coalition with Representatives Velasquez, Bishop, Grijalva, and Jennifer Gonzalez Colon to introduce this bill. I won't rehearse the long history of PROMISA, but without the conflict of interest provisions that this bill and your amendment seek to provide, companies that are hired to determine the best interest of Puerto Rico and its creditors can actually profit from their advice by investing in the debt instruments they are recommending in their fiduciary role. And according to news reports from the Wall Street Journal, New York Times, and others, McKinsey & Company is one of those advisors. While it is advising the Oversight Board on how much Puerto Rico should pay creditors, McKinsey's investment unit is one of those creditors, directly and indirectly holding Puerto Rico bonds. And as a bondholder, McKinsey's investment arm has a financial stake in the outcome of the bankruptcy restructuring. As feared when the Oversight Board announced the plan for how much to pay those bondholders in the restructuring, it was extremely generous to bondholders like McKinsey at the expense of the claims of other creditors. And that's why this particular bill became necessary. The PROMISA Oversight Board hired the law firm of Luskin, Stern, and Eisler to investigate McKinsey's potential conflicts of interest. And in that investigation, Luskin confirmed that McKinsey had not broken the law because such disclosures are not required under the current PROMISA. That's not necessarily a criticism of McKinsey. They complied with the law, but the criticism is actually back to the underlying law, which is why we need to make this bill happen. This bill requires attorneys, accountants, consultants, and other professional persons employed by the Oversight Board to submit verified disclosures of their connections with the debtor, creditors, or persons employed by the Oversight Board prior to being compensated under PROMISA. This simple change to the existing law will give the Oversight Board the information necessary to evaluate actual and apparent conflicts of interest so that proper action can be taken to mitigate such conflicts. This bill implements a major recommendation of the Luskin report on Puerto Rican debt structuring in line with the conflict of interest rules and standard bankruptcy laws, as the chairman has said. So with that, Mr. Chairman, I support your amendment and I support this underlying bill and hope that it really does a good job at ferreting out conflicts of interest and protects the process that we have going forward. Thank you, Mr. Chairman. I yield back.
The gentleman yields back. The question then occurs on the amendment and the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye.
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 Opposed, no. In the
No.
opinion of the chair, the ayes have it. The amendment and the nature of a substitute is agreed to.
Aye.
A reporting quorum being present, the question is on the motion to report the bill HR 683 as amended favorably to the House.
Hold on.
Those in favor respond by saying aye.
Aye.
No. The ayes have it, and the bill is ordered reported favorably. The members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 6196, the Trademark Modernization Act of 2020, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 6196 to amend the Trademark Act of
Without
1946.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 6196, the Trademark Modernization Act of 2020, is a bipartisan bill that will modernize trademark law to reflect technological advances, improve the efficiency of trademark registration, and address recent threats to the proper functioning of the U.S. trademark system. I am pleased to be an original co-sponsor of the bill, together with my colleagues on both sides of the aisle, IP Subcommittee Chairman Johnson, IP Subcommittee Ranking Member Roby, and Mr. Collins, the former full committee ranking member. A well-functioning trademark system supports a robust and successful commercial economy. Trademarks enable producers to build goodwill, and trademark protection prevents others from trading on that goodwill. By guarding against deception in the marketplace, trademarks also serve an important consumer protection function, which is especially critical today as electronic commerce commands a larger and larger role in the U.S. economic landscape. Federal trademark registration is an important component of protecting land trademarks and in turn in protecting U.S. companies and consumers. To function properly, the registration system must work for all entities, not just for large companies. For small and medium-sized businesses, it is especially important that the process of registering a trademark not be overly burdensome. Small businesses succeed when their brand recognition grows, and the heart of brand recognition is trademark protection. In recent years, it has become apparent that there are inefficiencies in the trademark registration process. It is also clear that marks have been registered that should not have been, either through inadvertent mistake or through fraudulent activity during the examination process. H.R. 6196 helps restore balance in the trademark system by creating new processes to allow even small businesses to challenge improper registrations through new, more efficient, and less costly ex parte cancellation proceedings. Excuse me. Clearing improper registrations from the trademark register allows those marks to be available again for use and registration by later legitimate actors seeking to build their brand and their business. The bill also modernizes trademark examination practice by allowing the Patent and Trademark Office to set trademark examination deadlines that are more in concert with the availability of electronic communications today. And it codifies an existing practice of the office that allows third parties to submit evidence to ensure that only those applications entitled to registration proceed out of examination. Additionally, for the trademark system to function properly, appropriate remedial relief must be available when a company's trademark is infringed. Given the consumer protection function of trademarks, to prevent confusingly similar marks from coexisting in the marketplace, trademark law has historically recognized a rebuttable presumption of irreparable harm when trademark infringement is proven. That presumption was called into question after a 2006 Supreme Court decision in a patent case. And since that time, a circuit split has developed over whether the presumption still applies in trademark cases. H.R. 6196 confirms that the historical practice of applying a rebuttable presumption of irreparable harm is the appropriate course for claims under the Trademark Act of 1946. This provision ensures that injunctive relief will be available in appropriate cases for parties prevailing on trademark claims. The changes made by this legislation would strengthen and modernize the trademark system, and I urge my colleagues to support this important bipartisan effort. I now recognize the distinguished ranking member of the Judiciary Committee, Mr. Klein, for his opening statement.
Thank you, Mr. Chairman. I want to thank Chairman Johnson, Ranking Member Roby, and former Ranking Member Collins for their leadership on this important legislation. Trademarks are among the most valuable and economically important types of intellectual property, with some trademarks being valued in the billions of dollars. American businesses depend on trademarks to protect their brands and products. Trademark protection allows in businesses, creating jobs, and producing better and safer products. Trademarks help prevent bad actors from stealing or taking advantage of the benefits of those investments, such as customer trust and loyalty. Trademark protections are particularly important for small businesses. Trademarks also protect American consumers who depend on them to identify the goods and services they trust for themselves and their families. Whether it's choosing to shop at a certain supermarket for food or choosing a certain brand of tires for your family car or truck, those choices are made based on trademarks, which is why it's so important to recognize that our trademark system is under attack. The vast majority of the world's most valuable trademarks are owned by American businesses. As part of its campaign to undermine the United States and American intellectual property, the Chinese Communist Party has been encouraging the filing of fraudulent trademark applications at the U.S. Patent and Trademark Office. They've literally been paying their citizens to jam our national trademark registry with thousands of fraudulent trademarks. As a result, American business owners have had to waste valuable time and money searching through numerous fake trademarks every time they launch a new product. American entrepreneurs have had to waste time and money sifting through dozens of fake trademarks every time they start a new business. Enough is enough. We must hold China accountable for its actions. We must act to stop this attempted sabotage of our trademark system and protect the countless Americans who depend on it. Existing tools have not been good enough. This important bill, H.R. 6196, the Trademark Modernization Act, provides the tools that American businesses and the USPTO need to fight against this tide of fraudulently obtained trademarks. The bill updates existing mechanisms to make them faster, more efficient, and more accurate, such as by codifying the ability of third parties to provide evidence during examination to prevent fraudulent applications from being granted. It also grants the USPTO more flexibility to examination of trademark applications. H.R. 6196 also provides new procedures to target these fraudulent trademarks and clear them from the registry. These procedures are designed to be fast and efficient so that businesses can quickly remove these obstacles and get back to work. The bill also includes procedural safeguards to ensure that these procedures are not abused and grants the USPTO the authority to enact further safeguards if needed. Finally, H.R. 6196 also clarifies certain aspects of trademark law to provide more certainty to legitimate trademark owners. I appreciate the hard work and effort that the sponsors of this bill put in for many months and appreciate their work to finally take action against China's misdeeds. Mr. Chairman, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 6196 offered by
Without
Mr. Bass.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. In addition to certain technical revisions to enhance clarity, the amendment in the nature of a substitute makes two substantive changes to the bill. First, it limits the period during which new ex parte and expungement petitions may be brought. The underlying bill allows new petitions to be brought any time after 3 years from registration of a trademark. The amendment requires new petitions to be brought within 10 years of registration after the 3-year period has expired. The amendment also provides for a 3-year transition period after enactment of the bill, during which this 10-year limit does not apply. This provision is intended to balance the need to provide repose for long-held trademark registrations that were legitimately procured with the need for streamlined proceedings to address improperly procured trademark registrations. The amendment also adds a new section clarifying the authority of the PTO director to reconsider decisions of the Trademark Trial and Appeal Board, including those that result from the new ex parte proceedings created by H.R. 6196. The recent decision by the Federal Circuit in Arthrex versus Smith and Nephew found that patent judges were appointed in violation of the Appointments Clause of the Constitution. To resolve the constitutionality concern, the Federal Circuit stripped patent judges of their civil service protections. The Federal Circuit has not yet ruled on the question of whether the appointment of Trademark Trial and Appeal Board judges similarly run afoul of the Appointments Clause. Structural differences between the Patent Act and the Trademark Act suggest that the outcome on the trademark side would be different. And importantly, language in the Trademark Act supports an interpretation that the director of the PTO, a Senate-confirmed official, has the implicit authority to reconsider decisions of the Trademark Trial and Appeal Board. The language added by the amendment, however, is intended to resolve any question regarding the constitutionality of the appointment of these judges. This provision should not be understood to give the director new authority. Rather, the new language simply confirms explicitly the authority of the director that is currently implicit in the Trademark Act. I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Johnson of Georgia seek recognition? Mr. Johnson. You may want to.
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. I was pleased to introduce the Trademark Modernization Act with you and my colleagues across the aisle, ranking member of the IP subcommittee, Ms. Roby, and also former ranking member of the full committee, Doug Collins, as well as with Senators Coons and Tillis in the Senate. Our bipartisan bicameral bill shows both the importance of the issue and the work we have done to achieve a consensus around the changes the bill makes to modernize the federal trademark system. The system was created by the Lanham Act in 1946 and has rarely been updated since, in spite of its importance to our businesses. Trademarks are unquestionably important to the American economy. One study shows that trademark-intensive industries contributed 23.7 million jobs to the U.S. economy in 2014. That's the last year for which data is available, reflecting the importance of the trademark system and the success of American brands. But as we learned from testimony in the Intellectual Property Subcommittee hearing I chaired last summer, the supply of good trademarks, pithy, catchy names, is not infinite. And already there's a short supply in certain industries. An important part of this bill would create proceedings at the Trademark Office to challenge and remove trademarks that were not properly in use to make room for the next generation of businesses. These same changes would also help address the recent rise of fraudulent trademark applications, particularly from China, that is currently harming legitimate businesses. The bill makes several other long overdue changes to modernize and strengthen the trademark system, updating the registration process and ensuring that trademark holders can seek redress in the courts to stop others from using a confusingly similar mark, a remedy that is key to ensuring that consumers know whose product they are purchasing. I urge my colleagues to support American businesses and protect consumers by voting for this important bill. And with that, I yield back.
For what purpose does Mr. Correa seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I respectfully urge the committee to amend the Trademark Modernization Act with a technical fix that will protect the franchise brands and small business owners in my district. I ask the committee to work with me to include the bipartisan Trademark Licensing Protection Act, that's HR 4164, as we advance reforms to trademark policy. In my district, franchises create over 15,000 jobs. Their businesses represent a significant share of women and minority-owned businesses. This simply protects the ability of franchises to maintain their trademarks. The Trademark Licensing Protection Act should have been part of today's legislation and would have provided a common sense bipartisan fix to this issue. With that, I yield back the balance of my time.
Mr. Chairman.
Does anyone else seek recognition?
Mr. Chairman.
Who seeks recognition? Mr. Gomert.
Yes, thank you. I'm thrilled that we've got bipartisan effort, not just one party, concerned about the assaults on our economy by China but I'm exceedingly concerned that this is brought up without a legislative hearing. I would think that we could have a bipartisan concern asking experts and people so we don't say we try to follow what doctors did for so long and trying to do no harm. I know when the copyright bill and supposed improvements were made, it devastated the brilliant but individual inventors. And one of the things that did that was the ability for the biggest moneyed people in the country and world to come in and challenge their copyrights after they'd fought the process and finally gotten recognized and given a copyright for their individual invention. So the big money folks come along, the huge corporations, and they challenge even after they've gotten the copyright, these individual inventors. So I have concerns. I would love to go after fraudulent efforts by China or Russia. I'm surprised they're not mentioned, but go after foreign entities that seek to destroy our economy and do so through the trademark system. But I'm also, I would love to have had legislative hearing where we could hear from experts. Is this going to allow, for example, the Chinese still assaulting our system, our economy, our government, come in and challenge trademarks after they're already awarded and say they're fraudulent? I'm just concerned that though we have a bipartisan interest in doing the very best thing we can, that we also, because we haven't, and we haven't done due diligence on this. So it's the best intentions, it's bipartisan, but we may be doing grave injustice to people that don't have big money to be overwhelmed by governmental companies around the world or even big companies within this country to come in and steal a trademark from somebody who simply doesn't have the money and the wherewithal to defend their trademark. So I wish that we could slow down. I know you're on course to get this passed today, and I know it's not normal, but I sure do think it would be a good idea to hear from experts to get a better view of just what damage could possibly be done by this bill. Again, with the best of intentions, it doesn't matter when you just start destroying the small moneyed people. I know Democrats have talked for years, used to, about trying to help the small folks, the people with small money or no money. Well, you may be helping the big money people here, and I would love to hear experts talk about that issue. So I sure would hope, Mr. Chairman, that we could have a legislative hearing instead of just ramming this through, thinking that we know all, see all, and can do what's best for Mount Olympus in the District of Columbia. So that's my take. I hope that we could push for that in a bipartisan way to make sure that we do no harm. And I yield back.
The question is, does anyone else seek recognition? The question then occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye.
Aye.
Aye. Opposed, no.
No.
In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill HR 6196 as amended favorably to the House. Those in favor respond by saying aye.
Aye.
Aye. Opposed, no.
No.
The ayes have it. Bill is ordered reported favorably. The members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We are now going to consider 4 private immigration bills en bloc. Pursuant to notice, I call up HR 631 for the relief of Arpita Kurdekar, Girish Kurdekar, and Vandana Kurdekar. HR 4225 for the relief of Maria Isabel Bueso Barrera, Alberto Bueso Mendoza, Karla Maria Barrera de Bueso, and Ana Lucia Bueso Barrera. HR 7146 for the relief of Victoria Galindo Lopez, and HR 7572 for the relief of Median El-Moustrah for purposes of markup. Without objection, I move that the committee report the bills en bloc favorably to the House. The clerk will report the bills.
HR 631 for relief of Arpita Kurdekar, Girish Kurdekar, and Vandana.
Without objection, the bills are considered as read and open for amendment at any point. The text of the amendment, the nature of a substitute to HR 4225 circulated to members last Friday is agreed to. I will begin by recognizing myself for an opening statement. As my colleagues are well aware, this committee considers private bills under the longstanding process and bipartisan agreement developed after the Abscam scandal in 1980. Under carefully crafted procedural rules, we consider only compelling cases in which removal of the beneficiary would result in extreme hardship or injustice. In making this assessment, precedent in the modern congressional era is an important consideration. In the modern era, Congress has passed several private bills where the extreme hardship that would result from the beneficiary's removal centers around medical issues. In each of the cases we are considering today, a beneficiary, or the U.S. citizen child of a beneficiary, suffers from one or more serious medical conditions that would undoubtedly be exacerbated if the beneficiaries were removed. The facts of each of these cases are compelling and uncontroverted. There's bipartisan agreement that each case meets the medical condition precedent. In addition, the Subcommittee on Immigration and Citizenship requested and received reports from the Department of Homeland Security on each of the named beneficiaries. None of the reports revealed derogatory information that would prevent us from proceeding with today's markup. As noted previously, we have made a minor modification to HR 4225 to an amendment in the nature of a substitute, which is necessary to remove the fourth named beneficiary, Ana Lucia Bueso Barrera, from the bill. Ms. Bueso Barrera is currently in the process of applying for lawful permanent residence to her U.S. citizen husband. As such, she no longer requires the relief that this bill would provide. In removing Ms. Bueso Barrera as a named beneficiary, the amendment also makes a technical change to ensure that upon granting permanent residence to the remaining beneficiaries, the Secretary of State reduces the number of immigrant visas made available to natives of the Bueso family's country of birth by 3 instead of by 4. I would like to commend the work of my friends and colleagues, Representatives Custer, DeTaulnier, Brownlee, and Tlaib, for their enduring support for these deserving families and for introducing these bills on their behalf. I urge my colleagues in this committee to vote to report these bills en bloc favorably to the House. I recognize Ms. Lofgren for unanimous consent request.
Mr. Chairman, I ask unanimous consent to place my statement in the record. The subcommittee acted unanimously on each of these bills, as you've noted.
Without objection. Does anyone seek recognition? A reporting quorum being present, the question is now on reporting the bills as amended and blocked favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no.
Aye.
The ayes have it, and the bills are ordered reported favorably. The
Aye.
members will have 2 days to submit views. Without objection, HR 4225 will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Let me remind members if they don't wish to speak, to mute themselves until they do wish to speak. Pursuant to notice, I now call up HR 5053, Justice for Juveniles Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 5053 to exempt juveniles from the requirements for suits by prisoners.
The bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 5053, the Justice for Juveniles Act, is a bipartisan bill that would eliminate the administrative exhaustion requirement for incarcerated youth before they may file a lawsuit challenging the conditions of their incarceration. This modest but important bill would correct a manifest wrong currently present in federal law established by the Prison Litigation Reform Act. The Justice for Juveniles Act would exempt youth from having to comply with the unfair administrative burden of having to exhaust their remedies before being authorized to access the courts. The PLRA's administrative exhaustion requirement as applied to youth is inconsistent with today's scientific understanding of the cognitive development of young people. Requiring a sophisticated understanding of how to navigate bureaucratic and technical procedures, this requirement is too high a burden for young people in custody to meet successfully. The Supreme Court has repeatedly held that a young person's immaturity and lack of knowledge might pose unique obstacles to navigating legal proceedings. In the 2011 case, the Supreme Court explained that failing to take age into account, quote, and thus to ignore the very real differences between children and adults would be to deny children the full scope of the procedural safeguards, close quote, to which they're entitled. The overwhelming number of experts recognize that differences in maturity lead in the correctional context to underreporting of assault and a general failure by youth to recognize the dangerousness of particular circumstances, which prevents young people from being able to effectively petition for changes in their prison conditions. In addition, the internal complaint system in correctional settings is rife with problems, which are exacerbated because grievance procedures tend to rely on written communication. Juveniles in the justice system often have educational deficits, lacking literacy skills to write a complaint or adequately to explain the nature of their concern. It is therefore particularly difficult for them to pursue complaints and satisfy strict exhaustion requirements. Courts have sadly been exacting in their requirements that the exhaustion requirements be followed, no matter how sympathetic the situation. A recent study of Prison Reform Litigation Act cases in federal court found that the law is often invoked to throw out juveniles' cases on technicalities, even in suits involving sexual assault or youth who are illiterate, deaf, or mentally ill. Despite acknowledging that there are cognitive differences between youth and adults, courts have not carved out on an equitable basis an exception to the exhaustion requirement. It is therefore up to us in Congress to address this serious problem. Exempting youth from the exhaustion requirement will not flood our courts with cases, and it may very well shed much needed light on unconstitutional practices that have been left to fester for decades. I thank Representatives Mary Gay Scanlon, joined by Representatives Armstrong, Reschenthaler, and several other of our colleagues for championing this issue and for introducing this bill. I encourage my colleagues to join me in supporting it today. I now recognize Mr. Klein for his opening statement.
Thank you, Mr. Chairman. I also want to thank Representatives Scanlon, Armstrong, and Reschenthaler for their leadership on this bill. Juvenile offenders often lack the knowledge to pursue and exhaust facilities. This bill eliminates some of the obstacles for juvenile prisoners seeking relief from our correctional facilities in federal court. H.R. 5053 will provide juvenile offenders quicker access to courts when they have been abused or mistreated. Builds on the bipartisan First Step Act and criminal justice reform signed into law by President Trump back in December of 2018, and it's an important step forward for criminal justice reform in our nation. And with that, I yield back.
Chairman Nadler, I think you're muted.
Mr.
I
Chairman,
move
you're
that
muted.
the chairman stay muted.
I think that's a good thing.
Oh, for what purpose does Ms. Scanlon seek recognition?
Thank you, Mr. Chairman. I'm really proud we're here today to advance the Juveniles for Justice Act. I, of course, want to thank my colleague, Congressman Armstrong, for his support and partnership on this effort. I think our cooperation on this legislation is a testament to the bipartisan accomplishments that are possible for our committee. And I also want to thank you, Chairman Nadler, Chairwoman Bass, and all my colleagues on both sides of the aisle who are co-sponsors of this bill. The Prison Litigation Reform Act, or PLRA, was passed in 1996 in an effort to decrease so-called frivolous lawsuits brought by prisoners. However, during the intervening decades, evidence has been growing that the law is overbroad in some respects. And there's now bipartisan agreement that one way in which it's overbroad is its inclusion of juveniles. And that's what we're hoping to remedy with this act. This common sense bipartisan bill would exempt juveniles from the requirements of the PLRA. As it stands today, that act dictates that youth in juvenile or adult facilities need to exhaust administrative remedies before they can bring a suit. It also limits the kind of relief they may seek, prevents them from bringing a suit for emotional injuries, and limits attorneys' fees, making it harder for young people to find attorneys to represent them. We know that youth are at particular risk for harm in juvenile and adult facilities. Studies show they're especially damaged by physical and sexual violence, harmful restraints, and solitary confinement. And so as they face unique challenges in complying with the administrative requirements of the PLRA, that's where the impetus for this bill comes from. As you mentioned, youth often lack the literacy skills, the understanding of the justice system, or the capacity to comply with those administrative requirements. For those of us who have kids or who have worked with children, it's easy to imagine the difficulty they would have navigating the complex legal systems necessary to raise allegations of abuse. So what we're trying to do here is address the very real impact of psychological and physical abuse on incarcerated youth. And, to the extent that there's any question about we need to act to correct this, you have to hear the story of the Glen Mills schools in my district. For almost 200 years, youth were sent to the Glen Mills schools to better themselves, to be set straight and come back to their communities. The institution was the oldest reform school in the country and accepted court order placements of juvenile offenders from across the country. But the school's longevity and its manicured surroundings masked horrors which were being experienced by the children, particularly in recent years. In 2019, there was an explosive report by the Philadelphia Inquirer revealing incidents of sexual and psychological abuse, broken bones, physical assault suffered by students at the hands of staff. And although the stories from the Glen Mills School are heartbreaking, they are not unique. Reports show that mistreatment of young people in juvenile facilities has happened in almost every state in the country. So at a time when coronavirus has put incarcerated individuals at increased physical and psychological risk, we think it's more important than ever to take steps to protect youth from abuse by passing the Justice for Juveniles Act. So I want to thank Chairman Nadler and the committee members and staff who helped bring this bill to markup. Also want to thank the juvenile justice advocates who helped us identify this area as being ripe for reform. And I would ask unanimous consent to introduce into the record the Philadelphia Inquirer article entitled Beaten Then Silenced from February 20th, 2019. And with that, I would yield.
Without objection, for what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. I want to thank my colleague, Congresswoman Scanlon, for leading this bill with bipartisan support from Congressman Armstrong, Jeffries, Katko, and Russian-Thaler. When young people are put in the custody of our prisons or juvenile detention facilities, it's critical that they are treated with care and they are treated with respect. As young people removed from the protection of their parents and communities, they are at a heightened risk for abuse. Juvenile inmates depend on prison officials to keep them safe and protected as they work towards rehabilitation. But too often, juvenile inmates experience violence, sexual abuse, or mental harm while they're in custody. For example, the 2018 National Survey of Youth in Custody found that 7% of youth in juvenile facilities reported being sexually victimized by either fellow youth or facility staff just within the past year. At one all-female facility in Georgia, 19% of the young women in custody reported experiencing coerced sexual contact, and we've got to do better. Our children deserve better. When youth in custody are harmed, it's critical that they have the ability to bring attention to their circumstances so that the courts or other government officials can step in to protect them, so that courts or other government officials will make sure that they're doing everything that they can to make sure that our children are not subjected to violent treatment. So the Justice for Juveniles Act takes the important step of making sure that procedural obstacles do not prevent important oversight to protect the rights of youth that are in custody. And I'm pleased to support this legislation, and I urge my colleagues to do the same. And I yield back the balance of my time.
The gentlelady yields back. For what purposes is Ms. Jackson-Lee seek recognition?
Mr. Chairman, I'd like to strike the last word.
Gentlelady is recognized.
Thank you. I too rise to support with great enthusiasm the bipartisan HR 5053, the Justice for Juveniles Act, and I thank my colleague, Congresswoman Scanlon. We've had conversations about her commitment and interest in juvenile justice, and I thank her for the leadership on this legislation, along with our colleague, Mr. Armstrong. For those of us who spent our time recognizing that the juvenile justice system should be reformed comprehensively, this is an important initiative. For those of us who have as well visited and interacted with juvenile detention centers around the nation, we know that in many instances, juveniles are sentenced without a sentence, meaning a juvenile can be sentenced to a juvenile detention center and continue to be in that center until the age of 21. It becomes their home. We also know with the reformation of the way states have written laws relating to juvenile issues or to school issues, unlike in quotes the old days, the auditorium detention turns into school police taking a juvenile for some infraction in the school straight down, as the kids would say, to juvie. And that means these children are then sentenced in quotes to juvie. Some do not have homes that families can support them. Some of them are just having difficulty in school. And so the inability to respond by civil rights cases for individuals who've been in juvenile for so long, subjected to forms of sexual abuse and other forms of abuse, have been another sentence on top of a sentence. This legislation protects young people from abuse in institutions by exempting them from the grievance provision of the Prison Litigation Reform Act. They can't wait by enabling them to file a lawsuit concerning physical injury, sexual assault, or mental abuse without first having to file an administrative grievance. These young minds, not matured until the age of 25, as science has indicated, these young minds, bodies can be so destroyed without ability to get relief. And so the PLRA was designed to address the problem of a large number of pro se prison lawsuits. This is not to recognize the crucial and urgent matter that a young person may be dealing with, particularly a young person that does not have access to a family structure that could be advocating for them. And so the ability to take the caps off, if you will, of the lawyer fees is likewise an important element of this particular litigation. I would like to indicate that it is important to recognize that the PLRA also has as a provision, if a person fails to comply with these requirements, including missing a filing deadline that can be as short as a few days, he or she may no longer bring a lawsuit. I want to cite into the record the Hunter versus Core, a 17-year-old sexually assaulted in an adult facility, but the case was dismissed because the court ruled that he should have exhausted his administrative remedies. We know that is very difficult for a juvenile. So I enthusiastically support this. And as I conclude my remarks, let me thank the chairman for your tremendous leadership during this Congress and the past several months of hardship, stress, and disruption, not only of the regular normalized operation of this committee, but of the Congress, and more importantly, the lives of the American people. It has been said of Americans that we do the difficult immediately and the impossible takes the longer time. We here in the state of Texas have faced not only COVID-19 hotspots, the recognizing of many who have died, but also Hurricane Karla. So I look forward to us working together on legislation. I look forward to having legislation that I've introduced, the HR 7636, the Custodial Interrogation Recording Act, and also HR 40 being brought to this committee as we continue to work in these difficult times, but as we continue to work on behalf of the American people. Again, I ask my colleagues to support Congresswoman Scanlon's legislation, which is HR 5053, Justice for Juveniles Act, and I'm delighted to be a co-sponsor. With that, I yield back.
The gentlelady yields back. I thank the gentlelady for her kind remarks. For what purpose does Ms. Dean seek recognition?
I move to strike the last word, Mr. Chairman.
Gentlelady is recognized.
I thank you, Mr. Chairman. I too rise in support of HR 5053, the Justice for Juveniles Act. There are nearly 60,000 children under the age of 18 incarcerated in America's jails and prisons. Their bodies and minds are developing. They depend upon adults for nourishment and protection, and their understanding of the world lacks the wisdom of experience. In short, they are easy targets for abuse in the harsh environments of our jails and prisons and detention centers. The Prison Litigation Reform Act created unnecessary obstacles for children, for young people seeking relief in federal court for abuse they faced in juvenile and adult correction facilities. It required incarcerated youth to file grievances before bringing a lawsuit, many times with the very people who have abused them. It limited the type of relief youth can get from the courts and prevents youth from bringing lawsuits for emotional injuries if they are unable to also prove physical injuries. What's more, it made it harder for young people to find attorneys to represent them because of the limits on attorneys' fees. I thank Representatives Scanlon, Armstrong, and others for this Justice for Juvenile Acts because it will remove many of these obstacles for incarcerated children. The measure of a society is how it treats its children, even those who have committed serious offenses, maybe especially those who have committed serious offenses. I am pleased to support this bill. I'm eager for its speedy passage, and I yield back. Thank you, Mr. Chairman.
The gentlelady yields back. For what purpose does Ms. McCarcel-Powell seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise in support of HR 5053, the Justice for Juveniles Act, and I'm very grateful to my dear friend and colleague, Representative Scanlon, for introducing this bill. This bipartisan legislation takes important steps to reform the Prison Litigation Reform Act, to give incarcerated people under the age of 21 the pathway to address dangerous prison conditions. High barriers currently exist for incarcerated individuals to bring a lawsuit to address prison conditions, like first exhausting all administrative avenues. Young adults and children are particularly vulnerable in our correctional system. When they're targeted or harmed, our current laws make it very hard for them to properly address terrible instances of physical and mental trauma. This issue, of course, affects thousands of juveniles across our country, and it affects juveniles here in my own district. The son of one of my constituents and a good friend, Ari, is a young man who is currently incarcerated. Like so many others, Ari's son has not received the adequate medical and mental health services that he needs to his detriment. Before being incarcerated, he was in a coma for 2 weeks and was transferred from the hospital only a few hours after he woke up from this coma. He suffered a traumatic brain injury and has yet to receive follow-up health services that he desperately needs. This bill aims to fix stories like this and provide the resources to address prison conditions for young people. And it's a great first step to fix and to work on criminal justice reform. I strongly support this bill, and I urge my colleagues to vote in favor of this bill. I yield back, Mr. Chairman.
The gentlelady yields back, a reporting quorum being present. The question is on the motion to report the bill HR 5053 favorably to the House. Those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 8124, the Criminal Judicial Administration Act of 2020, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 8124 to amend Title 18 United States Code to provide
Without
for
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 8124, the Criminal Judicial Administration Act of 2020, is bipartisan legislation that makes two modest but important amendments to current law, promoting the efficient, effective, and fair administration of justice. The first part of the bill concerns out-of-custody criminal defendants, particularly those who are released pending trial to live in communities that are located far from the courthouse where their cases are being heard. The majority of criminal defendants, federal criminal defendants, are detained pending trial, and the U.S. Marshal Service is responsible for housing and transporting them to court hearings, including trial. In addition, under current law, the court may order the U.S. Marshal to provide funds for a criminal defendant who is released pending trial but cannot afford the cost of travel to cover the defendant's travel to the location of the courthouse for trials or hearings. However, the defendant must fund their own way back home, and a defendant in this position would not be able to receive financial support from the U.S. Marshal Service for subsistence, such as lodging and meals. For an indigent defendant, these costs are sometimes insurmountable. For example, a defendant from Hawaii who must attend a 2-week trial in the Southern District of New York would have to figure out how to pay for 2 weeks of lodging in New York City. Or a defendant released to live at home on the Navajo Reservation who has a pretrial hearing at the federal courthouse in Phoenix, Arizona, may not be able to afford gas for the 6-hour ride back home. For years, our federal courts have struggled with how to assist indigent defendants when they find themselves in these difficult situations. But unfortunately, the court's efforts have come up against the text of statute. This bill would authorize courts in the interest of justice to order the U.S. Marshals to cover round-trip travel and subsistence for defendants who must attend court hearings but cannot afford to pay this on their own. The Judicial Conference of the United States has urged us to correct this grave unfairness, and I'm pleased to see that we are finally doing so with this bill. The second part of this bill, concerning federal magistrate judges, is also supported by the Judicial Conference. Magistrate judges have trial jurisdiction over certain misdemeanors, except for Class A misdemeanors, for which the maximum sentence is up to a year in custody. With the defendant's consent, however, a magistrate judge may exercise trial jurisdiction over a case involving a Class A misdemeanor. Magistrate judges frequently do so and often hear Class A misdemeanor cases all the way through judgment and sentencing. Under current law, a magistrate judge's jurisdiction ends after judgment is entered in a misdemeanor case and post-judgment jurisdiction reverts to the district court. Indeed, magistrate judges are not authorized to hear post-judgment motions, such as motions to vacate a sentence, even though they are the ones that handle the entire matter at the trial level and are best equipped to hear such post-judgment motions. Among other things, this bill would authorize a magistrate judge to hear post-judgment motions in misdemeanor cases in which he or she exercised trial jurisdiction. This amendment clearly improves judicial economy and makes perfect sense. I commend our colleagues, Representative Jeffries and Representative Roby, for bringing these matters to our attention, and I urge my colleagues to support this bill. I now recognize Mr. Klein for his opening statement.
Thank you, Mr. Chairman. I'll be brief. This bill comes at the request of the Judicial Conference, and it strengthens existing laws regarding the transportation and subsistence for indigent criminal defendants. The Judicial Conference offered reforms to improve our justice system, and their voices on such matters are appreciated. I want to thank the bipartisan sponsors of the legislation, and I
move to strike the last word.
For what purpose does Mr. Jeffries seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Ms. Nadler, for your continued leadership and for your support of this legislation. H.R. 8124, the Criminal Judicial Administration Act of 2020, is a bipartisan bill that would bring more efficiency and fairness to the criminal justice system by making two common sense improvements to the administration of justice in America. First, the bill would authorize courts to direct the U.S. Marshal Service to provide subsistence and return transportation to non-custodial defendants who are required to attend court proceedings but who are often financially unable to cover the entire cost of doing so. There's a small group of defendants who are not detained pending the outcome of their case and must travel to attend court proceedings, sometimes, as the chairman outlined, for incredibly long distances. Furthermore, while current law provides subsistence and travel to proceedings, there is a gap in the statute. HR 8124 would expand the existing statute to cover transportation, lodging, and food for defendants returning home from these proceedings. Second, the bill would authorize magistrate judges to decide post-judgment motions in misdemeanor cases in which they have already exercised trial jurisdiction. Magistrate judges try and sentence individuals in such cases, but to consider a post-judgment motion, current law requires a referral to a district judge or the party's consent. This provision would facilitate judicial economy and help reduce the caseloads of Article III federal judges by removing this requirement. The more efficient we can make our court system, the more effective it will be. These two non-controversial changes would meaningfully improve the ability of our federal courts to deliver justice for everyone. The Judicial Conference of the United States, the national policy-making body for the federal courts, supports this important and necessary bill. I thank the committee for considering it and for the leadership of the ranking member of the Subcommittee on Courts, Intellectual Property, and the Internet, Representative Martha Roby, for partnering with me on this effort. I yield back the balance to my time.
The gentleman yields back the balance of his time. Does anyone else seek recognition? Seeing that no one else is seeking recognition, reporting quorum being present, the question is on the motion to report the bill HR 8124 favorably to the House. Those in favor say aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.